This is a 3-in-1 video. Hello, my fam. It is Perez, the queen of all media, the original influencer, and your #1 source for everything It Ends With Us saga. Blake Ruin Your Livelihood is acting like she already won this case. And it's not over. The wife of Scarlett Johansson's ex-husband has gone on quite the victory lap this week. First, she went partying to a Chanel event in New York City. Yesterday, she threw her own party for her booze brand, even though she doesn't drink alcohol. And today, just a little bit ago, Blake Lives Matter and her husband were spotted out for a stroll in New York City. And this made my spidey senses tingle harder than Diddy at a freak-off. Here's why. I can't show you the pictures because I don't have the rights to the images. A media outlet got the exclusive in these photos of the two of them today, playing the part of doting parents. The photo agency is that one photo agency that celebrities all use whenever they want to stage pap walks. You know which one. I don't even need to mention their name. Also, because they've sued me in the past, so F them. A few extra things are of note here. 1, the two of them have the biggest eating grins on their faces. They clearly know the paparazzi is taking their pictures and they are all smiles. Plus, they don't go anywhere in New York City without bodyguards. In not a single one of these pictures do you see their bodyguard. Either they had no security with them or the bodyguard or guards strategically waited until the pap walk was over. The orchestrated media event. The image rehab moment. And I'm not usually a skeptic, but I'm not sure that their baby was in the stroller. They're all happy pushing the kid in the stroller. Show me the kid. I want to see the kid. I don't know if there was a child in there. Wouldn't that be hilarious? Additionally, lawyers for both sides keep getting richer and richer and richer. Multiple very different filings were just submitted to the court. My favorite is this. Remember how I told you that Insufra Blake was trying to get information from the independent third party who was conducting the workplace investigation after her allegations in the complaint with the California Civil Rights Department and her lawsuit? Even though the investigation is ongoing, she wants receipts, proof, timeline. And in today's letter to the judge, the Wayfarer parties argue the investigation documents are protected from disclosure by both the attorney-client privilege and work product doctrine. However, what makes this document today especially delicious is, in their letter to Judge Lyman, Team Baldoni Wayfarer cites a ruling from Judge Lyman. They remind the judge, quote, in Howard University versus Borders, this court denied a motion to compel the production of documents from an internal investigation conducted in anticipation of litigation. Boom. So the judge better rule the same exact way, or else it would be even more proof of his bias and that he's potentially been bought. Words matter, especially in a lawsuit, and the language in this next part was particularly. Lastly, they write to the judge, Lively concedes by her silence a point raised by the Wayfarer entities in opposition to the motion. that the disclosure of the investigation materials will risk chilling witness candor, distort the fact-gathering process, and undermine the neutrality that is fundamental to a credible inquiry. Plus, Lively does not dispute that such workplace investigations undertaken by counsel are privileged. So, for all the reasons listed, we respectfully request the court deny Lively's motion to compel. Meanwhile, the goddess of gaslighting submitted another motion to compel. This one against a former and current employee of the agency group, Melissa Nathan's company, his crisis PR expert. They tell the judge that these employees were served subpoenas in early March and where's the beef? They haven't handed over the requested information yet. And she went out of her way to help facilitate this. Specifically, Miss Lively offered to modify the requests to exclude requested communications with certain parties, including Baldoni, Heath, Sorowitz, and Abel, based on a mutual understanding that Miss Lively would receive the documents directly from the Wayfarer parties, which has not turned to be the case. I think they meant to say, which has turned out not to be the case. Whatever. They're filing so many letters and motions every day. Every single lawyer, associate, paralegal, assistant, every employee at all of these law firms deserve a raise and a vacation. Are none of them going on vacation until the trial starts in March? Crazy. Crazy. Every day there's so much insanity. Plus, the Penguin expert's attorney complains to the judge, quote, in June, when the parties appeared to finally be nearing agreement, counsel for Miss Case and Miss Coslow, the employees of the agency group, raised objections for the first time to the relevant time period and asserted new positions as to the requests. These late-breaking objections made clear that negotiated compliance would be impossible. Therefore, this court should compel compliance. The subpoenas seek information that is relevant to the claims and defenses and is proportional to the needs of the case, and they do not pose an undue burden. Miss Case and Miss Coslow were personally active participants in the digital campaign that features prominently in Miss Lively's pleadings. As individuals who witnessed and participated firsthand in the Wayfarer Party's digital efforts, their materials are highly relevant, indeed vital, to Miss Lively's claims, including her retaliation claims. Further, the requests are narrowly tailored to obtain communications of individuals known to have participated in the campaign at the heart of Miss Lively's suit, and who would have no relationship with the majority of the Wayfarer parties except for this participation. The TAG employees claim that the subpoenas pose a burden by seeking information that can be obtained by the Wayfarer parties. However, they remind the judge the Wayfarer parties have not produced a single document reflecting either Miss Case or Miss Coslow. So, Miss Lively respectfully requests that the court order Miss Case and Miss Coslow to produce all non-privileged materials responsive to the subpoenas no later than June 27th. All right, my friend, that is it for now. I am sure that I will be back for more because I am Perez, the queen of all media, the original influencer, and your number one source for everything It Ends With Us saga. So, thoughts on their attempt at rebranding? Image Rehab? Thoughts on all the legal maneuvering? Thoughts on anything and everything? Let's discuss now in the comment section.